Morning. Now we're working. Welcome. Today we'll hear two arguments, oral arguments in two proceedings currently pending here at the board. San Benito Railroad, LLC, acquisition exemption, certain assets of Union Pacific Railroad Company, finance docket number 35225, and Allegheny Valley Railroad Company, petition for declaratory order, finance docket number 35239. In an effort to move things along, the board members will not be making opening remarks this morning, but I wanted to cover a few procedural matters before we begin. We have asked each party to make a short statement of their arguments, but the council should be prepared to answer questions from the board at any time during your allotted time. I assure you that we have read all your pleadings, and there is no reason to repeat every argument. Speakers, please note that the timing lights are in front of me. You will see a yellow light when you have 1 minute remaining and a red light when your time has expired. The yellow 1 minute light will be accompanied by a single chime, and the red light signifying that your time has expired will be accompanied by 2 chimes. Please keep to the time you have been allotted. When you see the red light and hear the double chime, please finish your thought and take a seat. Additionally, just a reminder to everyone, please turn off your cell phones. The first argument will be in the San Benito case. Counsel for San Benito Railroad, you have been allotted 20 minutes. Please step up to the podium, introduce yourself, and indicate if you have reserved any time for rebuttal, and then begin.
Good morning, Chairman Elliott, Vice Chairman Mulvey, and Member Nottingham. My name is Kevin Shays. I'm counsel for San Benito Railroad. With me today is Janie Sheng, my colleague, who has joined me on the papers for San Benito. And watching on the live feed are the management of San Benito, who are very interested in the outcome of this case. We have reserved 5 minutes for rebuttal. San Benito filed a verified notice of exemption and a motion to dismiss that notice to obtain from the board a jurisdictional determination that the acquisition of the line in this case was not subject to the board's jurisdiction, and that after the acquisition, San Benito would not be subject to the board's jurisdiction. What I'd like to do this morning is spend a few minutes talking about the state of Maine line of cases and the conceptual framework of state of Maine. And then a few more minutes talking about how the framework of state of Maine fits squarely with the San Benito transaction.
Mr. Shays?
Yes.
Before you get into that, could you kind of get into a little bit about the status of this project? We understand that there is some litigation going on in district court, and we do have some concerns about whether or not the actual rail project will go forward. So we just wanted to address what you think if you foresee it proceeding.
Well, the only proceeding that's going to happen before this board is this proceeding, because the San Benito Railroad operation is an intrastate operation that will not be subject to Surface Transportation Board jurisdiction. I don't know, Mr. Elliott, what litigation you're referring to. I can give you a summary of the status of the project, if that would be helpful.
That would be great.
The San Benito Railroad's affiliate is developing a residential community, a whole town from a greenfield, at a point north of Hollister, California. This line would provide passenger rail service from that new community to the northern end of the acquired line at Cardinero, and then from that point, Cardinero to Gilroy on trackage rights on the UP Coast Main Line, at which point there's an existing Caltrain commuter rail service that runs to San Jose and then to San Francisco. The project is still in permitting with San Benito County and the state of California. There's no construction going on at this point.
Okay. Yeah, we were just we saw that there was some litigation in the Northern District of California. Are you aware of anything like that?
I'm not aware of any jurisdiction related to the railroad construction or the planned passenger rail service.
But what about with regard to the entire project? We understand that one of the managing partners has withdrawn, and that compromises the financing for the entire project. Could you at least could you speak to that at all?
There is a dispute between the owners and members of the LLC. The litigation, if there is litigation going on in the Northern District, well, you say there is, so I'm sure there is. It doesn't pertain to the rail line, and moreover, the rail line is an intrastate operation. We're seeking a determination that this acquisition of rail line would not be subject to the board's jurisdiction.
We understand that. It's just that there's no project, and there'll be no rail line. Then the board's time is valuable. We don't want to be spending our time on a project which is not going to go forward, or just make any determination on our jurisdiction over a line that may or may not ever be built. So you understand our concern.
I understand your concern. I would submit that the parties have gone to a great deal of expense to negotiate the transaction, and that we're seeking a determination that is not hypothetical, because it would be speculative to conclude at this point in time that the transaction will not take place.
Have you devised an operating plan for this railroad or this operation?
Other than the plan being to contract for passenger rail service, there's no operating plan because the operation is quite a few years into the future.
Okay. That's fine. Proceed. I'm sorry.
Thank you. As to the state of Maine doctrine, I think it's useful to think about hypotheticals to get a handle on the conceptual framework. So suppose a buyer is buying an extra width parcel of land adjacent to a railroad right-of-way. Suppose it's going to be used to develop some kind of a grain elevator or some facility for rail service. I think we would all agree that a railroad selling an extra width parcel like that would not need to come to the STB to get approval to do that, because the sale of an extra width parcel, absent bizarre facts, would not interfere with the railroad's continuing common carrier obligation on the adjacent track. If you move closer and think about a hypothetical where a buyer is acquiring a right to put in like a municipality to put in a water pipe underneath the right-of-way, or somebody is getting authority to cross a railroad right-of-way. Again, I think we would all agree that that kind of a transaction would not require board approval for the very same reason. The rights retained by the seller, the railroad, would clearly allow it to continue to meet its common carrier obligation. Well, I would submit to you that the state of Maine case, the concept in the state of Maine case is exactly the same. The idea is that the acquisition is just the stuff needed for the buyer's purposes and does not include the stuff, if you will, that's needed to continue the freight rail operation. So by a purchase that is subject to a retained freight easement that the seller keeps, and a contract between the parties that governs the shared use of the right-of-way, the parties achieve the very same thing that is achieved in the hypothetical involving the extra width parcel, or the hypothetical involving the underground pipe or the crossing. That's the conceptual framework for state of Maine.
Mr. Shades, if I could, is your point that railroad, what we commonly refer to as railroad right-of-way, can in many cases really refer to a bundle of property rights ranging from air rights to mineral rights to surface rights, and also in some cases to actual rights to take on the common carrier obligation and provide rail service for revenue?
Yes, that's correct. There are all kinds of uses of a railroad right-of-way. The board obviously cares most about the common carrier usage and making sure that any transactions that could affect the common carrier usage come before the board for an advanced jurisdictional determination. And if you look at the state of Maine case, the very last important point made by the ICC in that case is bring these transactions to us. They are fact specific. They need to be scrutinized and analyzed. And that's what people do. They bring these transactions in. I want to switch over to talk a little bit about this transaction. I've already explained that it's an acquisition from Carnadero to Hollister. I've explained that Union Pacific will retain a freight easement for continued freight use for its continued common carrier obligation. The separate piece of the transaction that relates to the San Benito's future passenger rail operations is from Carnadero to Gilroy, and it's a contract between Union Pacific and San Benito that essentially allows San Benito, when it starts its passenger rail service, to use whatever operator is already operating on that line for the Caltrain service, or to have its own contractor, which has to be approved by UP, to run the trains on this property between Carnadero and Gilroy. So the overall effect of the transaction is to allow San Benito to establish this passenger rail service from the community in the Hollister area north to Carnadero, then on to the UP main line via contract to Gilroy, where there's an existing passenger rail service run by Caltrain.
But excuse me, it does not require that without having a common carrier obligation, it is not subject, therefore, to the RLA, and therefore the people operating the trains, the contractor, or the people who maintain the right-of-way do not have to be people who have negotiated the contract, for example, with Union Pacific for that line. Is that correct? In other words, it could be non-union workers could work the trains.
That's correct. The service will be intrastate. It will not be subject to STB jurisdiction. Therefore, it will not be triggered as a carrier under the RLA or an employer under the RRA. They'll be free. The employees of the contractor will be free to negotiate collective bargaining agreements, but those agreements would be not be subject to the RLA.
Thank you.
Once the train gets to Gilroy, will there be any setup connection with Caltrain? Will there be a transfer between your railroad and with Caltrain, where they can actually get a transfer from your railroad and use it on the Caltrain line?
There will be no transfers. This is going to be a service where you go across the platform and you catch a train to San Francisco, you catch a train to points south, and to the point of law, you can use this service to get to Gilroy, cross the platform, and get on an Amtrak train that takes you outside of the state of California. That's not what the bulk of these people, these passengers, are going to be doing. The fact that you can do it does not establish this as an interstate rail service. Napa Valley Wine Train, Magna O'Hara, Fun Trains, all the cases in our papers clearly demonstrate that the fact that you can link everything doesn't trigger the jurisdiction of the board.
I'm a little concerned, though. I mean, I go back to my days with the bus industry, for example, when buses were deregulated. Many of the bus operations were intrastate. I mean, it was relatively short distance bus operations. But the rulings and the decision was by the Congress that all of these, because they connected with other buses that could provide intrastate service, were therefore part of the overall national network of bus services, and therefore were tied to the interstate network. Here, your train goes to Gilroy, where it can, as you said, meet up with Caltrans or Amtrak, etc., which brings you into the overall interstate network. So how do you carve this out as a most of we talk about purely intrastate or purely local rail services are very often the industrial tracks that are in plants or mass transit, rather than this kind of service, which clearly does connect passengers, even if it's not a majority of them, to interstate network.
Well, in the rail space, the case law is very clear, Napa Valley Wine Train, the Fun Trains case in particular, that the fact that you can link everything together is not sufficient if you don't have an arrangement that allows for interstate transportation. So, for example, if San Benito was going to have a through ticketing arrangement with Amtrak that would take people outside of the state of California, that would bring their future passenger rail service to the jurisdiction of the board. I don't know how it compares on the bus side, Vice Chairman Mulvey. I do know that the Supreme Court yellow cab case is informative on this same issue in the context of cabs, which is, I think, what you see the ICC relying upon in these intrastate passenger cases that I've mentioned.
These are mostly what you would call intra-urban cases, that is within a metropolitan area of some sort, rather than just intrastate. You can be intercity, especially in a place like California, San Diego to Los Angeles, or LA to San Francisco. It's intercity service, but it's still intrastate. The yellow cab, of course, refers more to intra-urban movements. So there's a distinction there, I think.
Mr. Shays, if I could, would you distinguish, if so, how would you distinguish the case you're presenting today with one that had a slightly different fact pattern, which was that San Benito, perhaps under my scenario, was not proposing to move people, but was proposing to move stone from a quarry facility to a manufacturing site where the stone would be used for an end product, and that would move by rail, but it would basically strictly be a intrastate movement over the same lines that you propose. Would your case be any different? Is there anything that would distinguish the two scenarios in your view?
Well, I think if you're talking about a freight move that is physically in one state, is that right? I think it brings you into a whole separate set of case law, and that generally the case law pulls the freight service in one state within the board's jurisdiction more readily because of other facts that relate to the commerce that's going on. We, of course, have no right to run freight trains at all on this line. We, in addition to UP belt and suspenders, in addition to UP retaining an exclusive right, we disclaim any obligation or any right to run freight trains.
And just a follow-up question: would there be? I think I'd like to hear you address the statute, the definition of rail carrier in the Interstate Commerce Act, which is in Section 10-102, subsection 5. Rail carrier means a person providing common carrier railroad transportation for compensation. Will there be, in fact, somebody providing common carrier rail transportation for compensation, namely the commuter rail service proposed from San Benito? And so, if so, who would that entity be?
The entity will be, in all likelihood, a contractor of San Benito. San Benito has the right to form in itself an operator on the line that it's going to purchase, but it has no right itself to drive trains on the connecting UP track. And so as a practical matter, it's probably going to be a contractor on the whole service. That service, either San Benito or the contractor will hold itself out to provide the passenger rail service from the Hollister area to Gilroy via these trackage rights. And in the definition section, the definition of rail carrier, a person providing common carrier railroad transportation for compensation. This operator will be that.
So there will be a rail carrier. It's just a question of who that rail carrier will be. It would either be San Benito or its contracted out entity, or both?
There will be a rail carrier under this definition. it will be either San Benito itself or more likely a contractor. But when you look at the board's jurisdiction, you need to look at section 10501. And there it says that in order for a passenger rail service to be in order for an entity to be subject to the board's jurisdiction, it has to be a rail carrier providing transportation as part of the interstate rail network. So the fact, Member Nottingham, that we will be a rail carrier is not sufficient to trigger jurisdiction because of the additional requirements of 10501.
Mr. Shays, I had a quick question regarding policy. My understanding of the state of Maine line of cases is that the policy that it was supposed to promote was to assist in the development of mass transit on lightly used lines. Can you explain exactly how you see that happening in this case?
Well, it is true that in this case, the establishment of this passenger rail service will help the passenger rail network in California. But the premise of your question is that the state of Maine case was designed only or specifically or even primarily for that purpose. And I don't think that's what I don't think that's what the cases demonstrate. The cases demonstrate a broader notion that you can use railroad rights-of-way for purposes other than common carrier rail service as long as you don't interrupt or interfere with that common carrier service. The original state of Maine case was for exactly the purpose that you identified. And the board, in fact, or the ICC, in fact, explained that part of the reason it was granting that specific transaction was that it would foster the ICC's policy to help states preserve rights-of-way for mass transit. And they refer to Bush Universal and the common carrier status of case of states' decisions that explain that. But there's nothing inherently limiting in the state of Maine as long as the board, as long as the freight common carrier service is essentially protected. There's no reason that the same policy can't be used to benefit other, to provide other public benefits, better utilization of railroad assets, other public uses besides passenger rail. There are all kinds of uses that could be made of railroad rights-of-way as long as the core common carrier is not interfered with.
But hasn't the state of Maine been primarily used for the public provision of transit services and private, giving the state of Maine exemption to a private operator would be different from past board policies? I know that one of the exceptions that's normally cited is Midtown Ventures with Grand Central Station, but in that case, the Metropolitan Transit Agency, a public agency, was also involved in that. So that sort of differs from your situation here. But are there other cases where the board has conferred state of Maine exemption on private operators?
Yes, there are only a few, but there are a few. The one that comes to mind that's in our papers is the Missouri River Bridge case, which involved no public agencies and no passenger rail motivations. Incidentally, there are a lot of these cases, Vice Chairman Mulvey, that deal with an earlier question. If you look at a lot of these state of Maine cases, they explain that the passenger rail service going on in those cases is intrastate. Not related to your question, but it popped into my mind. Besides, and then you also mentioned Midtown, which I believe is another case that's not a public agency and not a passenger use. But again, the fact that the first case and that most of the cases deal with passenger rail service, I submit, shouldn't be the core of your concern. It seems to me the core of the board's concern is the freight preservation of the common carrier freight use, and getting into why the transaction is, if that is handled, getting into why the transaction is going on is getting into the knitting of the business that's making the application. It's a different set of considerations, I would submit, for you to get into the knitting of the business if you've established that the freight railroad isn't going to be interfered with.
Mr. Shays, if I could ask, this I think is a natural follow-on to Vice Chairman Mulvey's question. The simple fact is that most of the quote-unquote state of Maine cases involve some public entity, some local government or regional government or state agency or entity that's interested in promoting typically passenger rail service or commuter service. But is that any reason to think that private entities or non-public entities somehow should be excluded from state of Maine jurisprudence? In other words, is there any precedent in property law that would say that a government entity is uniquely qualified to be recognized as owning one of those strands or some of those strands within the bundle of property rights that I referenced earlier, and a private entity is disqualified from being recognized as the owner of one or more of those strands?
I'm not aware of any such situation, and I think it goes back to the point of what's the board's role in these transactions. Property law, owners of the lines, Union Pacific has the right, I believe, to develop its assets as it sees fit, as long as it complies with the Interstate Commerce Act, ICC Termination Act. I think that's the basic answer to your question, Member Nottingham. I see that I'm in my last minute. The rest of my points relate to the union's concerns about the transaction, so I'll hold that for rebuttal. Thank you.
Thank you very much, Counsel for Brotherhood of Maintenance Away Employees Division of the IBT and Brotherhood of Railroad Signalmen. You have been allotted 20 minutes for your argument. Please step up to the podium, introduce yourself for the record, and begin. And Mr. Edelman, if you could kind of follow up on where we were just there with policy, that would be very helpful, just how you perceive the state of Maine policy that I was talking about earlier, assisting in the development of mass transit on lightly used rail lines, how that comes into play in these cases.
Sure. I think that was clearly an animating feature of the state of Maine case and the ones that follow. I mean, that's what they're talking about, and there's an explicit reference in there to wanting to facilitate public transportation, and that goes back to the common carrier status of state's case. On the other hand, my primary argument here is not whether or not they're a public entity, therefore they get to use state of Maine. My argument is state of Maine is wrong, and state of Maine is contrary to the statute. And one of the things I think that is, I think we've lost already in the discussion here is let's look at the basic thing that's going on here is San Benito proposes to buy a line of railroad that will still be used in interstate commerce by Union Pacific. Interstate trains, freight trains, will be moving over that track, and San Benito will own it and be responsible for maintaining it and dispatching on the line. That's a transaction that is subject to the Interstate Commerce Act. I think the fact that they go into the station at Gilroy and passengers can get on interstate through the trackage rights is also significant, and it undercuts their argument that they have that it's a purely intrastate operation that the board shouldn't be concerned with. But the fundamental fact is they are buying a line of railroad that will still be used in interstate transportation, and by Union Pacific. It's not like Union Pacific is abandoning this line and they are going back and the only travel on this line is back and forth between Hollister and Gilroy just for them. That's not what's going on here. They are buying a line of railroad, and their position is contrary to the language of the Act, contrary to precedent concerning non-carrier acquisitions of rail lines, contrary to precedent concerning the status of entities that acquire intrastate lines that are used in interstate commerce, and they are contrary to precedent concerning the expansion of the board's jurisdiction in the ICCTA. To the extent they rely on state of Maine, as we say, it's wrong. Now, let's look at the language of the Act. Commissioner Nottingham, you asked about that first. Act provides the board with exclusive jurisdiction over transportation by rail carrier over a line of railroad between a state and a place in the same state as part of the interstate rail network. The Act defines rail carriers, an entity that provides common carrier railroad transportation for compensation, but not the interurban electric railway. Railroad is defined as a road used by a rail carrier as well as track bridges, spurs, etc., used to move people or freight. So if one provides common carrier transportation using equipment for moving passengers by rail over tracks that are part of the interstate system, one is a rail carrier under the Act. But beyond that, and I've had plenty of experience with Section 10901, not all of it my most favorable, 10901 precedent says under that provision, a person that is not a carrier that may construct or acquire a line of railroad only by board authorization under Section 10901. There's an overwhelming body of precedent that says the Act regulates all line transfers either under 10901 or 11343, and that a non-carrier may acquire a line of railroad only if the board authorizes it or exempts it under 10901. I submit the hypotheticals you've heard are completely inapposite. We're not talking about buying a parcel of land on the side of the road here or a water pipe going underneath. We're talking about buying the rails on which the trains run. That's what this board is responsible for overseeing. Let's look at the precedent about the status of lines within a state that's used in interstate rail transport. The Staten Island Railroad case. The ICC held, the Second Circuit affirmed, that Sertoa, a state authority that operated a line wholly within the state of New York that was still used in interstate commerce for freight movements, was a carrier, even though Sertoa itself operated only intrastate. Sertoa had an obligation to maintain the line for interstate freight transport, had a latent duty to furnish freight service that was provided on the line in case the freight railroad didn't, and this was because the line connected with the interstate freight system and was used for service over that system. The court
wouldn't that latent duty to carry freight distinguish the facts from the case at hand?
I think not, because I think that there's a tautology in their argument. They say, look, we don't have an obligation to carry the freight, so we don't have a latent duty to carry the freight. But the point is, as owner of the line, under Sertoa, they do have a latent duty to carry the freight if the freight railroad doesn't. And that was part of the point in Sertoa. And the court in Sertoa specifically rejected an argument similar to that offered here that would distinguish the physical railway line from the railroad itself. The court said it was sufficient, not only that, sufficient for carrier status that Sertoa was responsible for maintaining the line and dispatching on the line. The point was that owning the line that's used in interstate commerce made it a carrier. That's the point. Common carrier status of states. The ICC held that when a non-carrier state entity acquires a line of railroad that has not been abandoned, the transfer of the line is subject to the ICC's jurisdiction, but they are exempt from prior approval.
Mr. Edelman, if I could ask,
yeah.
Putting aside just for the moment the specific facts of the case here, which I know is hard to do because we're having a hearing on this case, but if this were just a scenario where an investor, for whatever bona fide reason, perhaps he or she was interested in how the line of railroad and its underlying property and air rights and the whole bundle of property rights might impact neighboring land that the investor owned. Perhaps the investor had a vision to put in fiber optic cable on the rail right away. But can that investor carefully structure a transaction where they disclaim any rail operating interest, leave that to an incumbent provider or someone else to handle, but they do assume most or all the other components of that bundle of property rights?
I think if they acquire the line of railroad, they have that responsibility. They own the line. They have carrier obligations. And they have to come to you to acquire the line. They could acquire the fiber optic rights without becoming a carrier, I assume. San Benito could require trackage rights from Union Pacific to run their train from Hollister to Gilroy. They're buying the line. It is a piece of railroad in interstate commerce. I recognize that owning the line might come with ancillary property interests that might be sold, but they're buying the line. And I think that's the fundamental point here.
Just to dig into this a little further, suppose they bought the whole bundle of property rights and then actually sold pursuant to a very clear contract, the rail line, the track itself, and the common carrier obligation to another provider of rail service for compensation. Would there then be two holders of the common carrier obligation under your view, or only one?
I'm not quite sure I follow the specifics of your hypothetical, but if they've sold the whole thing, then they're not. I mean, when they own the line, they're subject to the board's jurisdiction. If they sell the line to somebody else, then they're not. That's the point. Ownership of the line brings those responsibilities with it. And I think if also, for example, I'll go into the ICCTA for a minute. The courts and the board have held that this dramatically expanded the board's jurisdiction over purely intrastate goings-on, spur tracks, a switching in a yard that was disconnected from the interstate system. That's the whole point. The board has jurisdiction over track that is used in interstate commerce, and that can't be, put away. So if we go to state of Maine, so what happened there? They file a notice of exemption, then a motion to dismiss. I think it's important nobody participated in that case other than the state of the parties. There was a half-page analysis of this. The board said it would appear to have jurisdiction over this, but it would let it go because of the freight retaining the common carrier obligation. They didn't identify in the Act any basis for an operating easement or for the notion that retention of operating easement could be utilized to defeat the ICC's jurisdiction. They just concluded the arrangement was sufficient to divest it of jurisdiction. And that's contrary to the Act, as I've explained. They're buying a line of railroad used in interstate commerce. The Act doesn't provide that you can acquire a line of railroad that is part of the interstate system and still used for interstate transportation without STB approval, just by agreeing with the rail carrier that was selling the line that it will continue to serve shippers on the line. That's basically what they're saying. And in calling this an operating easement doesn't change anything. There's no statutory basis for differentiating between acquisition of the line and acquisition of the land and rails and ties and ballast that are the line. And Sertoa specifically rejected differentiating the physical line from the railroad itself. And, that's something that the Act comprehensively lists numerous transactions involving conveyance of rail lines. Construction, acquisition, extension, consolidation, lease, acquisition of control, trackage rights, contract to operate, joint use, pooling. All of them are subject to the STB's jurisdiction. It's kind of funny, this statute got designed to basically regulate the behavior of robber barons. It was, extensively addressed them.
We have heard much about the issue of property rights, and that when you buy a railroad, when you're in operation, there's a bundle of rights that you have. But is there a common carrier right? It always strikes me, I always hear the term common carrier obligation. Now, rights have with them often obligations. And we're talking here about obligations. You can sell an obligation, I suppose. You can sell a right, but it is very, very different. And when we talk about state of Maine, we are talking about the common carrier obligation, and that being suspended, or that being the state being exempted from that. So, is there a difference here between the obligation and the rights, as discussed in a bundle of property rights?
I don't think so. I mean, interestingly, the Act sort of relies on common law definitions of what's common carrier, probably back to stagecoach days. But I think the point is, with the right to serve comes the obligation to serve, and I think that's the case. And that's part of the fact of ownership of the line and the obligation that comes with it, because if you have to maintain a line and take care of the line and give fair access to shippers on the line, this board is supposed to be able to enforce that obligation.
They're enforcing an obligation, not enforcing a right.
Well, they have the right. But I mean, so the point is, what's going on here in some ways is this notion that they're going to say, look, board, you don't have to worry about this. We, by contract, have arranged with Union Pacific that they'll take care of the things you're supposed to be concerned about, that the line will be kept up in sufficient order for interstate transport to take place, that the shippers on the line will be served, and we've arranged that by contract. But they can't contract out that obligation, and they can't contract away the board's jurisdiction and responsibility. But what happens if you say, we have no jurisdiction? And then somebody on the line, there's a shipper on the line says, I'm not getting service, or they're not maintaining it well enough to provide adequate service. The board has relinquished jurisdiction. And what happens if they go, well, that's okay, we'll go to state court. Well, the only parties to this contract are the buyer and the seller. What about the shipper? What about the other people that are involved? And suppose, sorry.
Doesn't Union Pacific have an obligation to maintain the rights of way, for example, if indeed San Benito is not part of the agreement?
That would have to be enforced by Union Pacific suing them. Or I guess Union Pacific would come in and say, oh, we'll do it and then we'll bill you or whatever. But that's all involved with contractual arrangements for them. They want to substitute for the board's jurisdiction. This is the board's statutory responsibility.
One other question on the state of Maine issue. Your view is that the state of Maine was wrongly decided,
yes.
But the board has decided a number of cases following the state of Maine principle. And how would you have us handle transactions that were already exempted under the state of Maine if we indeed want to follow your direction and overturn it?
I'm not going to ask the board to reopen all of the ones that have occurred. And I guess those people have an interest in their status. I would say that if you look at, and I think as I put this in my brief, if you look at all of those decisions that follow, none of them really engage the issue at all. This is like an echo chamber of one decision that had no statutory or decisional authority cited in it. It's half a page long, and all of the subsequent cases basically repeat exactly the same thing, and most of them were, again, ex parte. They weren't, nobody got involved in litigation. None of this has gone to a court of appeals. It's just rolling over, and basically this line of law is perpetuated because nobody got involved. Nobody said, hey, wait a minute. And we're saying, hey, wait a minute, this is wrong now, and it's look, we've had, in recent times, we've had New Mexico wide 300 miles of line in doing this. 300 miles of line that extends to the Colorado border. Using this, it's like, they start out with the state of Maine, 13 miles of line, kind of abandonable line. They want to save the service. And an important thing in state of Maine, by the way, is that the freight railroad was going to continue to be responsible for maintaining the line and dispatching the line. So, that's factually different, but I don't, again, the larger point of the analysis is that there is no basis for state of Maine in the statute.
Mr. Edelman, if I could ask a question. Let's assume that this board agrees with most of your points. Let's say we agree that this case presents a situation where we're talking about interstate commerce, that this track connects into any way you slice it. Currently serves interstate freight commerce and would connect in to interstate passenger under your theory. And so following that, there is, of course, a rail carrier that will be present, and the Rail Labor Act will apply. So putting that, let's just say that for argument's sake, that's a given. Why shouldn't a state of Maine, for example, which in their case was legally prohibited by state law, I'm informed, from operating a rail line, or let's say a private investor who, for insurance reasons or reasons of corporate policy, does not ever want to ever run and operate and be liable and responsible for the operation of a rail line. And they can either structure something through some kind of creative insurance policy or have a designated contractor ready to step in to take on that so-called latent common carrier duty. Do you see any flexibility in the law that would allow an owner, recognizing that RLA applies under that scenario, it's just some owners have very real reasons, such as the state of Maine, for not being able or wanting to actually have that and assume that that responsibility that they have no interest in assuming, but they are willing to guarantee that nobody gets left hanging high and dry without rail service, and that there always is somebody there as that backstop emergency provider?
I have two answers to that. I'm a little leery of extremely creative legal devices to move around regulation. I think we've all seen the bad results of that in the last couple of years. I think that you basically sort of, if you're buying a line of railroad, there's something that comes with that. You can operate on a rail line, but if the state of Maine wanted to do that, you can get trackage rights. I fail to understand what the problem is with this. Railroads operate on trackage rights all the time. And if you don't own the line, and all San Benito is doing is operating on trackage rights between Hollister and Gilroy, different scenario. But they're buying the line. Second, I would note that in common carrier status of states, the ICC said that if you gave the entirety of the rail operation to a carrier, then they would let the state not be a carrier. And that's what they did in common carrier status of states. Now, when you asked Mr. Shays a question about the third-party operator, his observation was going to be the third-party operator was not going to be a rail carrier under all the other laws because they're saying it's intrastate. So, there's a lot of slicing, a lot of the baloney extremely thin, so there's no there there. The point, so I think if you posit a situation where, somebody buys the line in its entirety and then says the entire railroad operation, running the trains, maintaining the track and signal system, taking care of the equipment that's going to run on it, everything goes to somebody who is a carrier, that's a different scenario. That's discussed in common carrier status of states. But that's not what you have here. That's not what you have in any of the other cases. So I think that's the point. And I do want to go back to Sertoa because I think if you overlay the facts of this case on that one, you've got the same thing. They're going to own a line of railroad connected to the interstate network. It's used for interstate transportation. It's responsible for maintaining the line and the signal system used for interstate movements, and it will control the dispatching of interstate trains. So that all runs together. My last point is just to say, with the ICCTA, if you say you have no jurisdiction, but the ICCTA and the cases under the ICCTA say states no longer have any jurisdiction over purely interstate things, then nobody has jurisdiction over this. And I think that's inconsistent with the Act. Thank you very much.
Thank you, Mr. Edelman. Mr. Shays, you have 5 minutes for rebuttal.
Correct. A couple of things. Let's start with Sertoa right off the bat. There are 2 reasons why Sertoa doesn't help the union's argument in this case. First, let's talk about what Sertoa had. Sertoa had a residual common carrier obligation and an obligation to maintain the track in question and dispatch all traffic on the track in question. And of course, there was a short line operator called SIRT, S-I-R-T, that operated on the line. This started out as a 1979 ICC case, and it went to the Second Circuit, where the Second Circuit said that the board's decision that Sertoa was a covered entity, that it was a carrier, was not unreasonable. That's all it said. That's all it said. Then, after Sertoa abandoned its latent common carrier obligation, and CERT, the short line, abandoned its freight operation, the D.C. Circuit said that the board was correct that Sertoa was not, the ICC was correct that Sertoa was no longer a carrier. Neither of the appeals courts ever had the question before it, what do you do with an entity that has no latent common carrier obligation but still maintains the track? So you can't get much from Sertoa. You really can't. And there's a separate kind of practical point. 1979 Sertoa ICC case. 1991 State of Maine ICC case. There's at least a generic legal argument that we can presume that your predecessors in 1991 understood their own prior decisions. But you don't even have to rely on that. Because if you look at the pleadings filed by counsel in the State of Maine case, you'll see that they fully discuss the Sertoa case. They fully discuss and distinguish the case. So you can be sure that in 1991, when the ICC issued the State of Maine case, they had the Sertoa case at the top of their mind. As to some of the other arguments made by the unions, 10501 and this notion of being part of the interstate rail network was not changed in ICTA. ICTA obviously made a lot of changes, but it didn't change this concept. The fact, therefore, that the board has broader preemption powers today is not relevant. In terms of 10901 and the fact that the statute says rail line The unions argued in their papers and essentially argued today that term is unambiguous, that it means a certain thing, that it means the tracks, it means the right-of-way. And that's not what that concept is. We're not talking about a definition of a physical asset. We're talking about a definition of what you have to be a common carrier. And the question of whether a transaction has taken away too much from the seller's common carrier. I submit to you that the term railroad line or line of railroad, as it sometimes appears in the cases, is not unambiguous. That is exactly what the board does when it interprets a set of facts that comes in under a state of Maine request. And this notion that these transactions are ex parte or that there aren't appellate cases that have somehow ratified or blessed the concept is beside the point. And since I have a minute left, I'll just offer one more thing. The contract clearly protects Union Pacific from the failure to perform on the part of the San Benito. There is express self-help provision if there's a failure of maintenance. And there's an expedited arbitration provision for any other breaches of that contract. So if there is a problem, if the shippers come to the board, if the shippers sue UP, if UP has a problem that's within the bounds of the board's jurisdiction, they have plenty of contractual rights to assert and defend their operation. Thank you.
Thank you, Mr. Shays. Thank you, Mr. Edelman. We'll now turn to the argument in Allegheny Valley. Counsel for AVR, you got to get up here first. Oh, no problem. Counsel for AVR, you have 20 minutes. Please state any time you're reserving for rebuttal. In addition, AVR has asked to present an easel-sized version of certain maps that were submitted as part of the record to aid in the discussion. We ask counsel that as you refer to the maps in your presentation, you reference each by its respective designated exhibit number in the proceeding so that the reporter will have an accurate record. Thank you.
I will do that, sir. Good morning. My name is Richard Wilson, and I represent the petitioner in this proceeding, Allegheny Valley Railroad Company. With me this morning is Mr. Russell Peterson, who is the CEO and owner of the Allegheny Valley Railroad. In a 1983, and I have reserved 5 minutes for rebuttal.
Sure.
In a 1983 conveyance to the Buncher Company, Conrail retained a permanent rail easement over a 1,500-foot by 90-foot parcel between 16th and 21st Streets in the Pittsburgh Strip District. And in 1995, Conrail conveyed that easement to the Allegheny Valley Railroad Company as part of AVRR's line of railroad pursuant to ICC Acquisition Authority in Finance Docket 32783. Allegheny Valley Exhibit D on the lower right-hand corner of the first exhibit is a copy of the track charts and valuation maps that were attached to the deed from Conrail to Allegheny Valley, and they explicitly describe and indicate the easement to be conveyed by Conrail to Allegheny Valley as part of that acquisition proceeding. Allegheny Valley Railroad Exhibit 2, which is immediately to the left of Exhibit D, is an aerial photograph that is a little difficult to see, but it attempts to depict the location of the easement parcel and its relationship to adjacent buildings, primarily the Pittsburgh Produce Terminal and the 16th Street Bridge and 21st Street. As I've indicated, these exhibits are in the record, and they, I think, give an indication of the parcel that's in dispute in this proceeding. Buncher now contends that AVRR's right to reinstitute freight and passenger rail service over this easement between 16th and 21st Street is somehow in doubt. In the board's December 1, 2009 order, you asked that we address whether the board has jurisdiction to consider this dispute in light of the recent D.C. Circuit Court of Appeals decision in Harsemus. And we have submitted briefs indicating that Harsemus is distinguishable both on the facts and the law from the case that's before you today. In Harsemus, that case involved a piece of railroad called the embankment, which was 6 separate blocks, elevated blocks of right-of-way, as the board is well aware. In the Harsemus case, one of the pertinent distinctions is that unlike the situation in the Buncher proceeding, Conrail retained no permanent rail easement over the embankment line. It clearly indicates that they did not see this as a line which they had continuing expectations to provide rail service over. The issue in the Harsemus case that was agreed to by both parties was whether or not the embankment track segment was part of a line of railroad which Conrail had received under the final system plan known as the Harrison-Jersey City line, which was identified in the final system plan as line code 1420. And the board found that it was a line of railroad, and accordingly Conrail required abandonment jurisdiction or abandonment approval and authority before they could sell it to a private developer. In reviewing that decision, the D.C. Circuit Court of Appeals in Harsemus said, wait a minute, this requires an interpretation of the final system plan. Only the special court has jurisdiction to review those plans, and since we don't have a special court, that jurisdiction now falls to the D.C. District Court. And that was the decision which we face in Harsemus. We think, and we've explained in our brief, there are some legal analytical problems with the decision of the D.C. Circuit Court of Appeals in Harsemus, but for purposes of the Allegheny Valley petition for declaratory order, the board doesn't need to address those. The Harsemus decision specifically indicates that there are many occasions when the determination of the status of a rail line will not require reference to the final system plan or to a Conrail conveyance deed.
Mr. Wilson, in this instance, wouldn't it be helpful to look at the FSP to determine when the actual transfer took place to Conrail, whether or not it was transferred as a main line of rail or a piece of yard track or interchange track?
No, sir, we don't believe so, because if you look at the record that we've presented to the board, there were significant changes in the way Conrail operated these lines between 1976 and 1983-84 when they created the interests which are in dispute at this point in time. You don't have to go back to the final system plan to evaluate those.
How was the line operated from 76 to 84?
Yes, 76 to 84.
How was it operated? Was it operated as a main line? Is that your?
No, it was not. in 1976, the Penn Central trustees retained property in the estate between 16th Street and 11th Street, never was transferred to Conrail. That, in effect, truncated the Railroad Street line that we have in dispute at 16th Street, and it was never a through railroad route after that. It was simply terminated the Conrail branch line that provided services to shippers at the Pittsburgh Produce Terminal between 16th and 21st Street. This gets extremely complicated.
So what you're saying is once the truncation occurred, I assume that was as a result of the abandonment that occurred in the early 70s, that that piece of line, the piece of line at issue, had become a piece of yard trackage? Is that what you're saying?
It was the end of the Conrail branch line that came into the Pittsburgh Produce Terminal yard, but that terminal yard, after 1976, when Conrail, and this is the piece north of 16th Street, that yard was dismantled, leaving only track number 8, which was the Railroad Street track and the track on which the easement was created. And Conrail continued to provide origination and termination services into the Pittsburgh Produce Terminal between 16th and 21st Street for up until 1993. That's what's shown on Exhibit H, which is the Conrail zone track service map that shows that Conrail continued to provide service.
I guess I'm a little confused because I think the argument that you were making in your briefs was that this piece of the subject line was mainline, and as a result it required some type of formal abandonment. And maybe I'm misunderstanding what you're saying here, that this track was yard track and then was pulled up, and then it wouldn't seem to be subject to our authority.
The track we maintain was mainline or branch line track that came into the yard, continued to be used for that purposes, and was never removed from the STB's jurisdiction. Now, Buncher argues that in 1984, in abandonment docket AB 167-558N, that Conrail abandoned track that included this easement. And we argue, and in support of that, they go back and try to invoke the final system plan as an indication that there was only a single line of railroad, and they argue that you can go back and look at the final system plan, or have to go back and look at the final system plan, in order to identify what tracks Conrail had for abandonment in 1984. There's at least 5 separate reasons why that's not a correct argument.
So from 1976 to 84, you're arguing that it is a mainline piece of track.
Yes, sir.
And do you have any, and that means what you're saying was we don't have to look back at the FSP because it was operated as a mainline. Do you have any evidence that you can point to in the record that demonstrates that it was operated in such a manner?
Well, for example, once Conrail abandoned the track under the Fort Wayne Bridge, the lower deck of the Fort Wayne Bridge, and the track connecting that Fort Wayne Bridge track up Smallman Street, which was the only track that Conrail abandoned in 1984, they changed their operations. And Exhibit F is the Conrail track chart from the 1984 abandonment docket. And it shows that there are 2 pieces of track that Conrail abandoned. The first one is the lower deck of the Fort Wayne Bridge, and then a connecting track from the Fort Wayne Bridge to 21st Street, which at that time the only track that existed that went between those 2 points was the Smallman Street track. And what prompted that abandonment...
How do you say that it was the only track that extended between those 2 points?
Because that's the track that Conrail identified for abandonment, and Buncher has argued that, also included within that abandonment docket is the easement on the opposite side of the produce terminal building, which Conrail had reserved in 1983, just 6 months before. Now, the change in operations is shown, can be seen on AVRR Exhibit A6. What happened is that after Conrail abandoned those pieces of track, it no longer had access into the produce terminal yard via the lower deck of the Fort Wayne Bridge. What it did, it transferred its traffic to the upper deck, ran it out along the Pittsburgh-Harrisburg main line, you can't...
Believe it or not, I understand what you just did.
Thank you. The change in operations enabled Conrail to run its traffic out their main line to Harrisburg and Philadelphia, and then switch off on the Brilliant Branch and come over and reconnect on the railroads, what I refer to as a railroad street track, bring it down along the river into the Pittsburgh Strip District and down to the track that ran between 16th and 21st Street, track 8 for the, as long as that track was in service, and even until 1993 to be able to serve the Pittsburgh Produce Terminal building.
So track 8 was operable then until 1993, and there was traffic going over track.
The record isn't clear. There was track, obviously, in 1983 when Conrail reserved the easement.
Mm-hmm.
When that track actually was covered over by Buncher or others is not clear on the record, but clearly it was operable, I think, by 1984, and in any event, by 1983, Conrail was still operating, as indicated by their track chart, over other track in that area.
What year again did Conrail convey the easement to AVRR?
1995.
1995. So the presumption would be in 1995 that there was an easement over an operating track.
In 1995, very clearly, this piece of track, which begins at I should say this piece of railroad right-of-way, because I think it's conceded by 1995. There was no...
Mr. Chairman, can I just ask one follow-up question?
Sure.
Mr. Wilson, if I could, just one question. What specific evidence in the record can you point to support your claim that there was actual rail service being provided in the early 80s? Or another way to ask that question would be, what's the most recent year in time that you can point to sworn statements, visual sightings, or any other evidence in the record that would give us comfort in agreeing with you that there was actually rail service in that year?
Well, for one, you have the Conrail tariffs and the Allegheny Valley tariffs, which contain the legal holding out of common carrier service to provide service to the Pittsburgh Produce Terminal. Those are in the record. There's also the verified statement of James Street, which is the current president for Allegheny Valley Railroad, who was at that time a Conrail train master, who describes the routes that were used and the service that was provided from 43rd Street Yard into the Pittsburgh Produce Terminal between 16th and 21st Street. So there, I think if you will look through the record, there is lots of indication that service was provided and continues to be provided to this day to shippers located between 16th and 21st Street.
Thank you, Mr. Wilson. Counsel for the Buncher Company will now proceed. You've been allotted 20 minutes for your presentation. Please step up to the podium, introduce yourself for the record, and begin.
Good morning, Chairman Elliott, Vice Chairman Mulvey, Commissioner Nottingham. Thank you for this opportunity to present the position of the Buncher Company. My name is Ed Fishman, and I represent the Buncher Company in this matter. I think it's very important to focus on the property in dispute and the track in dispute that used to be on this property. That track number 8, was taken up 25 years ago. We submitted a verified statement to the effect that track number 8 was removed between 1984, shortly after the Conrail abandonment, in 1988. That track has not existed for 25 years. There's been no service between 16th and 21st Street for more than 25 years. With all due respect to Mr. Wilson, I think that both in his pleadings and here today before you in argument, there's a tendency to sort of mix and match between the specifics of what was happening on the Buncher property and the general activities that were going on in the Strip District. The notion that Conrail was still serving customers between 16th and 21st Street up until 1995 is just not true. I mean, there was no evidence to support that. The track was removed. I was a little concerned when I got the letter from Mr. Wilson indicating that there would be exhibits presented today. I know the board's notice actually said something about no further exhibits, but I actually think these help us. So while it's a little bit difficult to review these in any standard evidentiary matter, I think I'd like to focus on Exhibit H, which is this 1993 Conrail ZTS map. And it clearly shows that track 8 no longer existed. The track that's coming in, the one that they show coming in and adjacent to the fruit auction building, is actually a completely different track. I think it's labeled here as the fruit auction track. Let me just get this right. So, track number 3, fruit auction. That's not our track. That's not the track that existed on the Buncher property. The track that existed on the Buncher property was removed shortly after Conrail filed for abandonment. Let's talk about the abandonment. Conrail filed for abandonment in 1984 on the Valley Industrial Track between milepost 0.0 and milepost 0.6. That covered the exact parameters of the property we're talking about here. It covered the Buncher property between milepost 0.3, milepost 0.6. Same milepost, same description, same name, Valley Industrial Track. It covered the same boundaries, 16th Street and 21st Street. Our position is Conrail abandoned this line.
Is that the piece of track that I know they're all, both supposedly called Valley Industrial Track? Is that the one that is also labeled as the Allegheny branch?
The Conrail abandonment, if you look at the abandonment filing, it just describes the track as the Valley Industrial Track. It says nothing about Smallman Street or Railroad Street. It says nothing about there being 2 different lines of railroad in this area. So we don't subscribe to this theory that there were actually 2 different lines of railroad.
Oh, no, I understand that, believe me. But is this would you agree that this is the branch that has been described as the Allegheny branch?
Yes, I think generally if you look at the final system plan, which is the starting point for understanding what Conrail got, line code 2229 as defined in the final system plan is described as a portion of the Allegheny branch starting at 11th Street, and that first segment, the segment that we're concerned about, extends to 57th Street. So this clearly is the Allegheny branch. Now, I do think Conrail may have redesignated this part of their system as the Allegheny secondary at some point, and the track maps that we submitted into evidence actually show that later on they started calling this the Allegheny secondary, but they weren't calling it anything else separately the Allegheny branch. So again, this theory that there was an Allegheny secondary and an Allegheny branch and that there are 2 separate lines of railroad, there's no independent evidence for that, and that's our position.
Okay, here's where I get a little confused. The way I see this abandonment as you describe it is it goes from the bridge all the way up through that branch up to, I guess, 21st Street.
That's correct.
And I looked in one of your briefs, and in 1972 you reference an abandonment which apparently relates, I think, to the same piece of line on where it was truncated back in the 70s. Would that be an accurate description of the 1972 abandonment?
I believe that's correct. I believe the 1972 abandonment, which was the Penn Central Transportation Company abandonment, applied to the line between milepost 0 and 0.2.
And that would have been between 12th and 14th Streets?
Roughly, yes.
Now this is the part that gets me. Why, in 1984, would they go back and apparently abandon the same piece of track?
Well, I think the answer lies in what Conrail got. I mean, basically, when the final system plan was developed and the conveyance to Conrail took place, it's almost like it was a reset. It was a clean slate. And Conrail, you got to look to what Conrail got. Line code 2229 started basically, I think, from that end of that first abandonment. Now, there may be a discrepancy in the milepost, and I can't completely reconcile it either. But I think you have to start with what Conrail got. And Conrail basically got from 11th Street on, and I think it's clear that the 1984 abandonment takes that entire part of their system out. It takes out from the Fort Wayne Street Bridge to 21st Street out of their system. And in subsequent maps, you see a gap. Conrail is no longer operating in that part. That part of their network is gone. And I think the other important thing to realize is, and you can see this on some of these maps, there are more than 30 tracks in this area. I mean, we're not just talking about one track. There are multiple tracks. And so we need to focus in on the track that existed on the Buncher property. And clearly, it seems to have been abandoned as a result of the totality of the facts and circumstances here make it clear that that track was taken out of the Conrail network.
Mr. Fishman,
yes.
I want to make sure I understand your statement that there was only one track, the so-called railroad street track. Are you saying that the record does not demonstrate that at some point in time there was a track running along Smallwood Street that was also generally referred to as the Allegheny Valley Rail track or part of the AVR?
Let me clarify. There were multiple tracks in this area, and my statement was intended to describe the track that existed on the Buncher property in dispute, which is a rectangular strip of land 90 feet in width. And there actually were 3 tracks on that parcel, so let me just first clarify that. There were tracks 6, 7, and 8 on that parcel that was sold to the Buncher company. Tracks 6 and 7 were actually sold outright to Buncher. Full title to those tracks sold. Conrail did reserve what I call a track easement, not a railroad right-of-way, but a track easement on track number 8. So the relevant track for purposes of this dispute is described in the reservation that Conrail made in the 1983 transaction with Buncher as the Valley Industrial Track, part of line code 2229. Now your question goes to whether there is a separate track emanating from Smallman Street that is also called the Valley Industrial Track. I have not seen that anywhere in the record.
I have not seen the track, the maps that show track along Smallman Street?
Clearly there's track along Smallman Street, but I have not seen anything which says that was the Valley Industrial Track. And the only thing that we have in the record that describes the track as the Valley Industrial Track is the reservation that Conrail made in the 1983 transaction with Buncher, and describes that piece of track as the Valley Industrial Track. So I can't say that the track that was along Smallman Street was also referred to as the Valley Industrial Track. I mean, it's all very confusing. But I think we need to focus on what the evidence shows, what the independent evidence shows. And there's nothing in the record that says there were 2 separate Valley Industrial Tracks, one on Railroad Street, one on Smallman Street, both lines of railroad. And that's our position.
In 1983 sale to Buncher by Conrail, and as you say, Conrail had a reservation reserving an easement over that line.
Right.
Was that indicative that they eventually intended to restore service and that the line therefore should not be repaved over, or that the line was paved over at some point?
We believe that reservation, and we submitted a verified statement to this effect, we believe the reservation was made because Conrail thought Buncher might be interested in receiving rail service. And Buncher is a company, real estate development company, that actually has some other operations outside of the downtown area that receive rail service. So I think that's one reason why Conrail may have reserved this easement. The second reason is they hadn't abandoned the track yet. And so it makes sense to me that they would reserve an easement, and it's important to recognize the narrow scope of the easement. It's not a railroad right-of-way easement. It's an easement to use and continue to operate on the existing Valley Industrial Tract. In my mind, that's very different from reserving an easement for perpetual common carrier operations. But back to your point, we think that was reserved because they thought Buncher might be interested in rail service, and also because they conveyed the property before eliminating the common carrier obligation. Now, 2 months after conveying the property to Buncher and reserving the easement, they filed a notice of insufficient revenues under NERSA to initiate the abandonment process that they used. And then shortly after that filed their abandonment application, which was granted in May 1984.
And at that point, you could then pave over it.
At that point, the track was removed.
Mm-hmm.
And let's remember that this track had always been surrounded by concrete pads, which I think is another indication of the way that service was provided in that area. But the track was removed, the area was paved, and since 1984, maybe the time period between 84 and 88, that property has been paved over, and Conrail has never objected.
That track was removed by Conrail or by Buncher?
We don't actually know. I mean, this goes back more than 20 years, and unfortunately, the institutional knowledge, the people who are around in the Buncher company at that point, actually don't know whether Buncher physically removed it. I mean, certainly someone would have hired a contractor, we think, to take that track out. We don't know if it was Buncher, if it was Conrail, if it was both of them. We don't know who got the scrap value. We just couldn't find any records.
That was my next question. Who got the scrap value of the rail?
We don't know. We don't know. Unfortunately, we did not find the documentation which explained who got it. What we do know is the track was removed. Let's remember, Conrail, kept track in that area. It's not like Conrail completely disappeared from the area between 16th and 21st Street, but their track starts at 21st Street, and that's the track they conveyed to AVRR. So they're still in the area. They never made any attempt to attract rail service to that region, to indicate to Buncher that they were continuing to use this property for rail, to preserve it in any way. At a certain point, the fruit auction building, which used to be served by rail many years ago, with produce, now it's all truck service. And at a certain point in time, the trucks were continually driving over the Buncher property, and that forced the Buncher company to basically put up Jersey barriers. Again, demarcating this was this property. No one ever objected to that either. So, I mean, I think the totality of the facts and circumstances here clearly demonstrate that Conrail's intent clearly manifested, that it abandoned this property. There was no intention to preserve its ability to provide rail service at any point in time.
Another question regarding the abandonment. In your final brief regarding Harsmus, you make a very strong argument why Harsmus would apply here, and why we don't have jurisdiction and it's subject to the special court's jurisdiction. If that in fact is the case, how would that argument apply to the 1984 abandonment in this instance? Wouldn't we, if your argument goes, wouldn't we be without jurisdiction to have made that decision in 84?
I'm not sure how to address the point of looking back to the 84 abandonment, but what I do think is important, I think it's important to recognize that to the extent, Harsmus is clear, that to the extent the board relies substantially on final system plan evidence, then in order to make a determination in this case, then that's an issue that's within the exclusive jurisdiction of the special court. But I actually think that the board can reach a resolution in this case and determine that the property was abandoned without actually relying on that final system plan evidence. I think there's enough here, if you look at the 84 abandonment on its face, if you look at the Conrail track charts, if you look at what happened in the area, the track was removed. The admission seems to be it was never a line of railroad, which is a little bit different from the position AVR I thought took in the briefs. But I think the totality again is that this track was taken out of the rail network. There was never any common carrier obligation that was preserved. And so I think there's a way the board can actually resolve this case in our favor without getting into the Harsmus issues, by not necessarily relying just on the final system plan evidence. I think there's additional evidence.
Would that run counter to your argument that you made?
I think it's a little bit of a clarification. We indicated in the pleadings that we thought there was sufficient evidence before the board to rule on this case. the reason why we thought Harsemus would control is because of the argument that AVR is making, that there are two lines of railroad. And I think if you believe that's credible and you have to rebut that argument, you look to the final system plan. But I actually think there's enough evidence in the record outside of the final system plan which would allow the board to make the determination here without getting into that issue.
Mr. Fishman,
Yes, sir.
if we were to decide that there is a rail easement still in existence, what happens then? Where do you locate that? How do you find out where the location of that easement might be on the Buncher property? The property, as I understand it, it's been described as somewhat like a parking lot right now, kind of a paved open space. Is that a fair description?
That is correct. I believe that currently the entire rectangular strip of parcel at issue is paved over and is being used for parking.
There's no evidence or markings or anything that would tell us where the actual track, if there was a rail easement, still in existence, where that would actually be located.
I believe that's correct. I think you'd have to actually get a surveyor out onto the property to figure out where the track formerly existed, and then again, we dispute that there is an easement. We also dispute the scope of the easement. I mean, the easement clearly, when it was reserved, only applied to the existing track, and this created what looked like a 36-foot in width envelope, basically. AVR's position is it covers the entire 90 feet, and we vehemently dispute that. We vehemently dispute that they have the ability to construct passenger rail platforms and tunnels and other things for the service. So, but to your point, we don't know where I mean, you'd have to figure out where the track is.
That dispute, if it is in dispute, would be taken up, I assume, in state or local court. Be a property type dispute.
Certainly, a state court would have jurisdiction to interpret the scope of the easement.
How narrowly do you define this easement? I mean, if Buncher or some unknown third party in the middle of the night had just back in the 70s or 80s had just gone up and torn up the track, and all of a sudden the next day there was no track, would you be saying that with the track went the easement?
No, we're not saying that, and I don't think that's our case. I mean, clearly this was not a track that was removed by vandals. I mean, this was track that was removed by design. I just unfortunately cannot tell you. We cannot submit evidence that says the Buncher company pulled it up or Conrail pulled it up, because we don't have the records and we don't have the people around anymore who actually have actual knowledge. But we do know that the track was pulled up with everyone's consent and authorization, and so I think that's not our case. I think this was understood. And look at the context again. Buncher owns a lot of property. We're focused on this one strip, but Buncher owns much of the property in that strip district area between 16th and 21st Street. All the trackage is gone. If you look back at the old maps which have been submitted into the evidence, there are hundreds of tracks there. They're all gone.
So the issue of abandonment centers on the railroad's intent. And sometimes we get a letter saying that we're formally abandoning it. Without a letter, there has to be certain actions. So what actions do you proffer are determinative of Conrail's intent to abandon the 1984 letter? That seems to be unclear as to exactly what was included in that. Is there any ambiguity there that you see?
I don't think so. I think that it's important to focus on the fact this was a NRSA abandonment, and under the Township of Bethel decision in the Third Circuit, NRSA abandonments effectively become effective when the ICC issued the certificate. There was no further need to file a notice of consummation. I mean, the law is clear on that, and let's also remember why NRSA was enacted, to expedite Conrail's abandonment process. I think that the subsequent actions that were taken clearly show an intent to abandon common carrier service in this part of its system. There was no holding out. There was no attempt by Conrail to ever provide service in this area, to ever indicate that it still was interested in retaining this track or this property as part of its system. Thank you.
Mr. Chairman, if you have a question,
I have one quick question, and you can follow up.
Just quickly, I will give Mr. Wilson notice. I'm going to ask both counsel the same question. But is there any evidence in the property records in the deeds or recordation books of this easement being recorded, so that Buncher, ideally in property law, when you go to look at buying a property, we hope that the records are clear. You go down to county courthouse or city hall and you pull up the land record and you say, wow, it's burdened by an easement. Okay, maybe we pay a different price for that property than if it's not. Any evidence in the record of any such documentation?
Well, I believe that the real property records were recorded, and I think the important point is you're getting to expectation. The important point is that the Buncher Company acquired other properties in this area, and Conrail actually reserved some track easements in those other properties too. And there's correspondence. The very interesting thing is there's correspondence where we didn't submit it into the record because it really wasn't germane to this property, but there's correspondence where Buncher was notified that once Conrail pulls up the track, the easement's rights expire. That was the expectation that the Buncher Company was under, and I think that's very normal. I mean, this is 20, 25 years ago. There was a reservation of a specific, to continue use of a specific track. That track was removed. There was never any attempt until recently when ABRR came out with its plans to provide passenger rail service. There was never any indication that anyone was reserving any further rights to that property.
I had one last question. In 1995, when I guess this transaction took place, were you aware that Allegheny Valley was seeking these rights to operate over this line?
No. Speaking on behalf of the Buncher Company, I wasn't representing them in 1995,
Right.
but I don't believe they were aware of the fact that a 7-day wonder in those days, if a notice of exemption was filed in 1995 with the ICC. Remember also that the map attached to that notice clearly shows the line dead ends at 21st Street. No indication in that notice that there was any attempt to obtain authority to operate on track between 16th Street and 21st Street.
So you, as the owner of the land, weren't aware that this, to the best of your knowledge, that this was going on at the board?
That's correct.
Okay.
Thank you.
Mr. Wilson, you have 5 minutes, I believe, for rebuttal.
Thank you, Your Honor. Let me respond to the questions that Commissioner Nottingham posed. Yes, there is a survey. We can identify the precise location of the easement tract. It can be identified through surveying marks out. There's a meets and bounds description that is available. Second, when you look at what Conrail describes as the Valley Industrial Tract in its 1984 abandonment application, you can look in that abandonment application and it indicates quite clearly that the easement property between 16th and 21st Street was not included in that abandonment application. In first place, there is a description of the tract to be abandoned that describes it as overhead track with no originating or terminating traffic. That describes only the tract that ran up Smallman Street and was used by Conrail to get to the 53rd Street yard to bring traffic back down into the Strip District. The track that we are talking about, the track 8 on the easement, that was a track that was used to originate or terminate traffic. Finally, Conrail states in its abandonment application that it has no property interest in the connecting track, and that's because that track lay in a public right-of-way or portions of it had been sold to the Pittsburgh Urban Redevelopment Authority when they acquired the produce terminal. Conrail would not have represented to the board that it had no property interest in the track it was seeking abandonment when 6 months before it had retained a permanent rail easement. Next, we would contest strongly that this was...
Mr. Wilson, is the survey that you mentioned in the record?
I don't know whether we submitted it in the record or not, but it can be identified.
If you did not, could you please submit it for the record?
I will provide a copy for the board. The other, so we believe that the abandonment application on its face, read in its totality, describes only what we call the Smallman Street track between milepost 0.0 and the north side of 21st Street. We would also argue that the easement, which Conrail retained in 1983 and then transferred to Allegheny Valley Railroad in 1995, is not just a track easement. We note in our pleadings, and as pointed out by opposing counsel, there are other indications where Conrail retained an easement and specifically stated in the easement that upon cessation of use of that line, the easement would terminate. That is not the language contained in the easement retained by Conrail over the Buncher parcel. So Conrail and Buncher clearly could specify when they created a so-called track easement as distinguished from what we believe is shown in the 1983 deed as a permanent rail easement. There is no language in that deed that indicates there was any intent on the parties to terminate the easement when that track was removed. Finally, that easement was recorded.
With respect to that deed, the same question I was asking Mr. Fishman was, did you provide Buncher notice of this proceeding, that traveling over the, getting the right to operate over this line?
I don't know whether explicit notice was provided to the Buncher company by Conrail or AVRR when they filed their notice of exemption, because I didn't represent them at that time. The notice of exemption itself identifies the milepost numbers for the track in question and the milepost numbers for the line of railroad which was approved for acquisition by the ICC in 95 start with milepost 0.3, which is identified as the north side of 16th Street. That's in the
I understand you abided by what was required to put and mark the milepost down, but don't you think it's strange that Buncher wouldn't be provided notice as a landowner?
I don't know whether that was done, and I don't know whether that was explicitly required at the time. Yes.
Does the sale in 1995 of the easement to AVRR by Conrail somewhat imply that Conrail did not intend to abandon that in 1984? Otherwise, Conrail is selling something it no longer had the right to sell, correct?
We certainly think that indicates that Conrail believed they had a permanent rail easement for future railroad use, and they conveyed it to AVRR at that time. I think that's a very strong indication of Conrail's intent not to abandon that.
So at least what you're saying is at least for the last 15 years, Conrail had sold something. Well, 15 years ago, Conrail sold something it believed it still had the authority to do.
Yes, I believe so, sir.
And your position is that they sold something that they did not have the authority to sell because they had abandoned it effectively in 1984. Yes. Yes.
Certainly, that is our position. I also think that what happened is the Conrail Real Estate Department looked back and said, what do we have, and let's give whatever we have. But it was a quitclaim, so they can only quitclaim what they had, and our position is legally they had no easement. Thank you.
And you were not aware of that at the time?
That's correct.
Okay, thank you.
Thank you very much for your excellent arguments, and the meeting is now adjourned.